Hello everyone, I hope you're having a good day and you're staying safe. I'm Sesa Gill, a legal intern at LEXIS and Company, and today I'm going to be talking about the contract of bailment. Now, Section 126 of the Indian Contract Act 1872 deals with the contract of guarantee. It defines it as a contract to perform the promise or discharge of liability and of the third party in case of his defaults. Now, for example, let's talk about if A grants a loan of 10,000 rupees to B and C promises A that if B cannot repay the loan, he will do it himself. Now, that is the contract of bailment. That is the contract of guarantee. It involves third parties, namely. Now let's talk about the three parties of the contractor of guarantee. First is surety, who gives the contract. Second is principal debtor, in respect to whom the default of guarantee is given, and the creditor to whom the guarantee is given. Now we can talk about the essentials of the contract of guarantee. First is concurrence of all parties. The surety, the principal debtor, and the creditor must agree on making a contract. Then is liability. In a contract of guarantee, liability of surety is secondary. That is, the creditor must first proceed against the debtor, and if he latters to perform his promise, then only can he proceed against the surety. Now we're going to talk about the third essential of the contract of guarantee, which is existence of a debt. Now, a contract of guarantee presupposes the existence of a liability, which is enforceable by law, of course, and if such a liability does not exist, there is no contract of guarantee. Consideration. There must be a consideration between the creditor and surety as it makes the contract enforceable. The consideration must be lawful, and in a contract of guarantee, the consideration received by the principal debtor is taken to a sufficient consideration for the surety. Now, fifth is writing is not necessary. A contract of guarantee may be oral or written. It can be expressed or implied for the conduct of parties. Now, a very essential part of any contract is the offer, the acceptance, the intention to create a legal relationship, the capacity of contract, a genuine and free consent, legal object, lawful consideration, and possibility of contract and other such legal formalities. There is no concealment of facts. The creditor should disclose the surety and the facts that are likely to affect the surety's liability. The guarantee obtained by concealment of facts is invalid. Thus, the contract is invalid if the creditor obtains it by concealment of material facts. No misrepresentation. The contract should not be obtained by misrepresentation of facts to the surety. Thus, the contract of guarantee is not a contract of absolute good faith. Thus, it does not require complete disclosure of material facts by principal debtor or the creditor to the surety before he enters into a contract. Now, let's quickly talk about the two kinds of guarantee. First is specific, and the second is continuing. So let's talk about specific first, which is a contract to a single debtor or a specified transaction. It comes to an end when such a debt is been paid off. Now, a continuing guarantee is a type of guarantee which applies to a series of transactions. A continuing guarantee applies to all transactions entered into by the principal debtor will be invoked until it is revoked by the surety. Now let's talk about the two situations where the discharge of surety can take place, which comes under section 130 and 144 of the Indian Contract Act. So first is the death of surety. The death of surety is as regard to future transaction. In case of continuing guarantee is the absence of contract to the contrary. Now, a notice of revocation. The notice of revocation as regard to future transaction in case of continuing contract can discharge a surety. Can be a discharge of a surety. Now, the last topic that we're going to be talking about today is the right to a surety. First is the right against the creditor. As per section 141 of the Indian Contract Act, a surety is eligible to the benefit of to every security which the creditor has against the principal debtor. It holds even true when if at the time of entering into a contract of guarantee, the surety is unaware of the existence of such securities. Now, the second one is rights against the principal debtor. Once the surety discharges the debt, he obtains the right of a creditor against the principal debtor. Now he can sue the principal debtor for the amount of debt paid by him to the creditor due to the default of the principal debtor. Rights surety's rights against co-sureties. When a surety pays more than he shares to the creditor, he has the right to contribution from the co-sureties, who is equally liable to pay. For example, if A pays the full amount to surety to the creditor, he has the right to divide it with other co-sureties and pay the exact amount. So I hope this was an interesting topic and you were able to understand about the contract of guarantee. Thank you so much for watching and do subscribe to the channel. Thank you.